it's important that people who do the wrong thing are held accountable for any of the crimes they commit. And by holding them accountable, you also have a very good chance of deterring them from committing offences on a later occasion.
A lot of witnesses, when they come to court, are very nervous and they don't understand the court system. So we're there to provide that support, sit with them, explain the process and assist them with dealing with the prosecutor and I guess explaining what's going to happen at court.
Meet Sandy. It's not her real name, but she's helping to tell a very real story. Sandy was assaulted by her husband. She suffered injuries that could have killed her. Police are investigating the incident.
It happened on Friday night. I was out with my girlfriends and we were drinking and smoking quite a bit. When I came home, I asked Robbie for a cigarette and he got really mad. And he got so mad that he slept on the couch. The next morning, I tried to sweeten him up with a cup of tea and I asked him for another cigarette and he got real angry. He got so angry that he dropped the tea and it spilled everywhere.
Now, what do you think you're doing?
Look what you've done.
These are my smokes.
Now I have to go clean this up.
Yeah, go and get them then. Go and get the mop and clean it up. These are my smokes, okay?
I grabbed a mop and a bucket to clean it up. He grabbed the mop and he hit me on the side of the head with it.
Damn mop.
Robbie, calm down.
No, I'm not going to calm down. Look at now, look at this.
When a crime is first committed, it's important for police to speak to the victim and the witnesses and the offender and get everyone's side of the story. Depending on victims, it can be quite painful and tough for them to relive these memories, but it's important the police get as much detail as possible about the incident.
Well, I didn't feel anything at first, and then I felt my head and I felt a cut and there was blood. And my sister was over, so she took me to the hospital. And when I was in hospital, the police came to talk to me and they said that what Robbie had done was a serious crime and that he was in big trouble.
As a result of the police investigations, Sandy's partner Robbie was arrested and charged with assault causing serious harm. This is a very serious crime, which means it will go to the Supreme Court.
All right then, here you go.
All offenders are entitled to bail. It's a case-by-case basis. If they are admitted to bail, the protection is offered as certain conditions are imposed. They might be not to contact the victim, not to go anywhere where the victim or witnesses might be living, staying or working. And if they do breach those conditions, they'll be arrested by police and they may be held until the next court date.
Once the police have laid charges against an accused, the matter comes to our office where a file is created and the matter gets a court date in which both parties, I suppose, can set down how it wants to proceed, whether they want to proceed by way of a plea of guilty or not guilty. And we then obviously notify witnesses and complainants and let them know, I suppose, when their matter is coming to court.
Well, when I got the letter from the justice people, I got worried. The letter said that Robbie had been charged and it had a date that I had to go to court. I got worried because I didn't want to see Robbie and I didn't want to tell strangers my story. So I wanted to have all the charges dropped.
At the outset, it's obviously very important to us what a complainant feels about their matter, because it is their matter, and we know and indeed take into account very strongly the wishes of the complainant or a victim. But there are cases where, particularly with the safety of a complainant is at risk, or the safety of the community is at risk, and sometimes there are, not very often, but sometimes there are cases where, as an independent prosecuting authority, we have to proceed with matters even if a party or a complainant might not wish to.
After the police have completed their investigations and charges have been laid, it can take a while before a case is heard in court. There are things that need to be done during this time.
Well, what we do is we help the witnesses understand what's going to happen at court and explain the legal terminology. We assist the prosecutor, and we also assist with preparing a victim impact statement, and we also refer witnesses on to counselling or other support services as they require.
I really wasn't prepared for court. I didn't know what was going to happen and I felt nervous and unsure, so knowing people were there to support me really helped.
Victim impact statements tell the court how victims feel about what happened and how the crime has affected them, emotionally and physically.
A victim impact statement is a statement that is presented in court, and the victim writes the victim impact statement and writes down the effect of the crime on them. And basically a victim impact statement is important for the magistrate or the judge to help understand the effects of the crime on the victim.
Writing the impact statement was really helpful, and it was much easier than I thought. And it reminded me of why Robbie needed to learn from the lessons of a crime he'd done, and that he can't just go around hitting people. And it made me realise that he did really affect me and that his behaviour was just unacceptable.
Matt, this is Sandy.
Hi Sandy, good to meet you.
Nice to meet you.
Please be seated.
The Witness Assistance Service works with the prosecutor to help victims prepare for court.
Part of our role, a big part of our role, is to try and make each witness comfortable, to explain to them what the court process is and what their part in that process is. A lot of people aren't familiar with the process, and it's something very different, something very new, and obviously sometimes quite scary for them. So we try to make them feel a little bit more comfortable, that it's about really them telling their story to the court.
The charges against Robbie are extremely serious, and the case has gone to the Supreme Court.
A lot of the witnesses will come along to court with their families or other support people, and to sit with them at court. Basically what we'll do is we'll make sure that everyone's at court with the assistance of the police. We'll make sure everyone's ready and prepared to go into court, so go over their statements with the prosecutor. Each of the witnesses have to go in one at a time, and usually they'll wait outside until the court orderly comes out and calls their name. Then they'll walk into court to give evidence.
In the trial process,
there are special people who work here. The Supreme Court is far more formal, and the most serious crimes, including murder, are held here. The judge sits here, and in front of the judge is the judge's associate and court staff. All the lawyers are more experienced and often called barristers, and they all wear big robes and wigs. They all sit at this table. The Crown Prosecutor sits at the end closest to the jury. The accused's barrister sits at the other. The accused sits in the dock with a court guard next to them. At times, a jury of people will come in to help the judge decide if the accused is guilty or not. The jury of 12 people is picked by chance from the electoral roll, the people who vote. If the jury finds the accused guilty, the judge will decide on the sentence. The witness will sit here. Some people may not be able to give evidence directly to the court. There are provisions for them to apply to the court to be a vulnerable witness.
A vulnerable witness is usually a child under the age of 18. It could be a sexual assault victim, or it could be, sometimes with Indigenous women, they talk about women's business. They'll either use a closed-circuit TV room, or sometimes it could be through a video link through another town or community.
Well, there are various categories of vulnerable witnesses. Child witnesses are by law vulnerable witnesses. A child is, for those purposes, someone under the age of 18. A witness who is the alleged victim of a sexual assault or sexual offence is also by law a vulnerable witness. A witness with a particular disability is also a vulnerable witness. In that case, the court has to determine the nature of the disability and to determine whether that person is to be treated as a vulnerable witness.
Silence, all stand. This honourable court is now resumed. Please be seated.
In the matter of the Queen against Robbie Clark.
Thank you, Ron. Please, the court, my name is Nathan.
Are you Sandra Clark? Miss Clark, when you give evidence in court you have to take an oath, but you have a choice whether it's a religious oath or a non-religious oath. Do you have a preference? Thank you. I'll ask you this question then. Do you promise to tell the truth to this court?
Yes, I do.
Thank you. Please sit down.
It's obviously a very foreign environment, so first thing I try and get witnesses to do is just try and relax as much as they can. And that is to realise fundamentally that they're there to tell their story. The lawyers don't really know what happened, and we have to rely on our witnesses to tell us. So it's empowering witnesses, letting them know that it's that when they first get on the witness box, the prosecutor will ask them the questions, and it will just be about encouraging them to tell their story. Ms. Clark, could you tell the court your full name?
Sandra Clark, and people call me Sandy.
Thank you, Sandy. Can you tell the court where it is that you live at the moment?
I live at 21 Smith Street, Jabberi.
Yeah, and who else lives there with you?
I live there with my husband Robbie Clark and my son Patrick.
Okay, and Robert Clark is the accused, seated in the dock?
Yes, that's right.
Now, Sandy, I'm going to ask you some questions about the 6th of April 2013 and an incident that happened on the morning of that day. Do you recall that time?
Yes, I do.
And could you tell the court what happened on that occasion?
Yes, well, the night before I was out with my friends and we were drinking at the pub, and you really wonder how many times you have to keep telling your story over and over. The prosecutor is good and it feels like they're on your side, but with the defence lawyer it can be a lot tougher, and you just have to stick up for yourself and you can't just say yes or no for the sake of it. You really have to tell exactly what happened.
We then move on to cross-examination, and that's where the defence lawyer will test their evidence. So they'll ask questions that will put pressure on them and to try and ask about detail that they might not necessarily remember. But again, there are things that you will remember and things that you won't, and all you have to do is the best that you can. And the court appreciates that, and so does the jury.
So would it be fair to say that when you came home you were drunk?
No, I might have been tipsy, but I wasn't drunk.
Okay. And when you came home the night before, you had an argument with Mr. Clark at that time?
Yes.
And that argument was about you being jealous of him with other women?
No, it wasn't about that. It was just about cigarette.
In fact,
it wasn't about that.
You have a history of getting jealous of Mr. Clark being around other women.
I'm not jealous at all. It was not about that. I don't get jealous.
Once all the evidence is heard, it's up to the jury to decide if the accused is guilty or not. If the jury finds the accused guilty, then the judge will decide the punishment, known as a sentence, straight after the trial or on another day. The accused has 28 days to appeal or fight the decision. If the jury finds the accused not guilty, they'll be free to go home.
In order to find a person guilty of an offence, the members of the jury have to be satisfied beyond reasonable doubt of each of the elements of the offence. Sometimes there are technical elements, sometimes there are aspects of credibility as well, but a finding of not guilty doesn't mean necessarily that the jury hasn't believed the principal witness or any of the other witnesses in the case. It simply means that the jury has not been satisfied beyond reasonable doubt as to all those matters.
Ladies and gentlemen of the jury, are you unanimously agreed upon your verdict?
Yes.
On the charge that on the 6th of April 2012,